Bob's.
Well, welcome back, everybody. It's my pleasure to be moderating this afternoon's panel on the Massachusetts Miracle.
Massachusetts Miracle.
We're not used to that in New York, giving anybody any credit for anything. So I have to say that I was so excited to see that Terry figured out that there are other places to learn from than the 5 boroughs of New York City or the upstate counties of New York State. Um, the earlier sessions provided us with significant evidence that New York's laws regulating um, the built environment need to change, and they need to be more flexible. The status quo reduces our state's economic competitiveness. I need to talk louder. Okay, is that better? Okay, you want me to start again? Okay, so just to recap, um, we all recognize that the current laws regulating the built environment need to change. They need to be more flexible. The status quo reduces our state's economic competitiveness. It creates extraordinary inefficiencies. And finally, it stifles creativity, leaving us deeply rooted in the last century, unable to take full advantage of the technology and building innovations of the 21st century. The current law of design, bid, and build is clearly broken, and as all of us know who have worked in any large organization, especially in government, it's not enough to know you have a problem. It's not enough to know the solution to that problem. You also have to know how to implement change. And I've had some experience with Terry Matthews, who organized this conference. She's probably the best person in city government that I know who actually gets things done, actually understands the intersection between a problem, a solution, and implementation. Which brings me to our good friends from Massachusetts who agreed to talk to us this afternoon. They're here today because they changed their laws, which some say were even more arcane and dysfunctional than the New York State laws, if that's actually possible. And so during our panel this afternoon, we'll discuss both the political process, the drafting and vetting of legislation, and the substantive changes that have been made in Massachusetts. And the purpose of this discussion is really quite simple. What can we in New York State learn from the Massachusetts experience? Of course, that's deceptively simple. We can probably learn a lot. Whether we do it or not is another question. And this, we hope, will ultimately produce our own new law. What I'll do is briefly introduce the members of the panel, and then each one will present some aspect of the change process. And then we'll have a couple of questions and a response from a member of our New York State government. And I hope there'll be some questions from the audience. It's a big group of Massachusetts people with only one member of our New York State government, but we know you can handle it. So before I pass this highly organized panel over to our colleagues from Massachusetts, as I said before to some of the members of the panel, I've never had the experience of moderating a panel where the panelists organized themselves so effectively that I didn't really feel the need to do much of anything at all. So I hope I can just keep it moving in an effective way because they have a lot to share with us. Our first speaker, and I'll just go through the speakers very quickly, is Bob Petrocelli, who is the CEO and Associate General of the Association of General Contractors of Massachusetts. He'll be followed by Mary Caitlin McSally, the General Counsel of the Massachusetts Building Authority, then Carolyn Francisco, a partner in Corwin & Corwin, LLP, which is a firm that specializes in construction law. Janet Chrysos, Deputy Director of the Massachusetts State College Building Authority. John Nanari, Associate Executive Director of the Massachusetts chapter of the American Institute of Architects, AIA. And Stan Martin, a partner in the Boston offices of Duane Morris, also in construction law. And then finally, we'll have Ryan McAllister, who is the senior counsel in the New York State Senate Republican Counsel Program Office. So I'd like to ask Bob to begin by providing an exploration and an introduction to Massachusetts' reform approach.
Thank you very much, Esther. We really appreciate being here, and because we have such a large panel, we'll try to quickly go through our remarks and then have more time for discussion, for questions and answers. But I was here this morning and heard some of the panelists talking, and we will definitely talk about how there is now alternative delivery in Massachusetts. There are multiple tools in owners' toolboxes, design build for highway projects and CM at risk for vertical projects, and how this all came together. So I'd just like to start off by talking about there was a perfect storm of events that happened between 2000 and 2004 in Massachusetts that resulted in the most sweeping changes in public construction reform in the past 30 years. There was an alignment of interests of all the stakeholders, including the legislature, the executive branch, the general contractors, the subcontractors, the building trades, the non-union segment, the minority contractors, and all the state agencies as well. It all came together. I don't want to say it's by happenstance, but it just seemed to be everyone was working on different things like you are right now, and there was a gelling thing that came together that came across with the construction reform legislation. Prior to 2003, when the legislature actually convened its Public Construction Reform Commission to come up with ideas for new law, the basic tenet in Massachusetts for the building side was the design bid build system with a component of the filed sub-bid system. I don't want to say it's like your Wix law, but people have compared it to that, where pretty much the filed sub-bid system was in effect since 1939 on public building projects, which basically names statutorily 17 filed sub-trades that were to bid directly to the awarding authority. A week later or so, the general contractor would then submit their bid and using the selected filed trades. And typically that general contractor would select from the lowest among them, otherwise he would risk not being low in himself, or risk having a bid protest by the second low subcontractor. Some of the pitfalls certainly were that it was kind of forcing bad marriages. The subcontractors weren't pre-qualified. The general contractor never even sometimes heard or saw or were familiar with the subcontractors beforehand. And in the same time, though, some of the positive aspects were that it did prevent bid shopping and it did protect the subcontractors' prices. So that seemed to be the lay of the land in Massachusetts. That law still is in effect today, because when we did do construction reform, we wanted to improve on that system, but we also kind of went around it when we started implementing the alternative delivery. So we understood that there was a great deal of support for the filed sub-bid from the building trades and from the subcontractors, but so we needed to understand to protect certain interests of certain parties in order to improve the effectiveness of new delivery systems with the other parties. What happened, though, there was a growing drumbeat from municipalities, from the state agencies, that this seemed to be an ineffective process. They looked and saw what was happening in the private sector. They looked out the office buildings of the state office buildings and saw that the city of Boston was being built pretty much through CM at risk. And they realized that there's got to be a better way to build a building than this. A lot of the municipalities were complaining that they were getting poor quality general contractors, poor quality subcontractors, because they would bid on a project and certain municipalities would probably build only one school every 10 years and then they'd go off to the next city or town. So we really realized that there needed to be a different way of procuring construction. Around the year 2000, several things were happening. At that point, the Mass State College Building Authority, and you'll hear from Janet Chrysos, was already starting to experiment in teaming approaches and getting special legislation for that. DCAM, which was the state's biggest awarding authority, the big building agency for the Commonwealth, received a new commissioner. It was David Perini, formerly of Perini Construction. He had retired from Perini and was asked to be, or tapped to be, the new commissioner, which was a terrific idea. He understood construction. And he had a lot of ideas for alternative building and alternative delivery systems, including a new courthouse package of 4 new courthouses that he was starting to look at doing in alternative delivery. The Massachusetts Municipal Association, which comprised of the 351 cities and towns in the Commonwealth, they were banging the drum trying to repeal or radically reform the filed subbid system. A lot of the public owners, especially at the municipal level, and we heard it from this morning's panel, were pretty much sometimes unsophisticated building committees from smaller cities and towns, and they really couldn't manage this. It was very hard to manage these processes. The cities themselves were starting to have home rule petitions, which pretty much meant they were exempting themselves from the public bidding laws. So in one sense, the AGC was certainly trying to find a way around the filed subbid system. So we kind of applauded that, but at the same time, our contractors are calling us saying, this is becoming the Wild West. The cities and towns are not only exempting themselves from the bidding laws, but there's no protection for general contractors, no protection for subs, there's no consistency from city or town. So they were just procuring as needed with no protections or no built-in regulations. So, and at this also at the same time, Governor Romney spoke at a hearing or spoke at a dinner at the Mass Municipal Association and actually called for the repeal of filed subbid. At that point then, Joe Corwin, the attorney for the Corwin and Corwin and counsel for the associated subcontractors, called me and said, we've got to do something about this because things are going to be changing without our input. And we agreed. And so we agreed to sit down with the associated subcontractors and start talking about a different system, how we could get ahead of the curve and offer some interesting and new perspectives on alternative delivery. We then joined up with the Boston Society of Architects, which was a major component of the Massachusetts AIA. And when we started talking about what could we do for a different type of system, at that same time, David Perini was actually drafting his legislation for, I think it was at that point, it was looking like construction management at risk for 4 courthouse projects. I know he invited in associated subcontractors to help advise him on ways to protect subcontractors. He called us in. I know Stan Martin helped with some of the crafting of that language. And so just as that legislation, that model legislation, that kind of like that pilot legislation was going through, we were sitting down with the subs and the architects. And when we sat down and really talked about it, we said, geez, what would we like to have for a nice piece of legislation? The general contractor said, we want to be able to go in first and work with the designer and the owner to kind of craft the scope of work. Under filed subbid, the architect was responsible for divvying up the scope of work. And they really said, we just want to design. We don't want to be responsible for that. It really should be the general contractor. So we said we wanted to get in early, and we wanted also to pre-qualify the subcontractors to get a better class of subcontractors and kind of get to know who they are in advance. And the subcontractors were saying, well, we agree. We think that perhaps the CM or GC should come in front and should do the scope. But we want to protect our pricing. We want a direct form of, we want a 2-page form of contract because we don't want to have these private CMs or GCs coming in and coming up with a 50-page contract for subs. We want a statutorily protected contract, and we want a right to direct payment. And we all looked at each other and we said, this almost sounds a little bit like CM at risk, where the CM could come in up front, and then this way the subs would be vetted, and we said maybe even bonded, and I know the subs agreed with that. So we actually came up with, after 9 months, this kind of draft CM legislation. At the very same time, the legislature in 2003, after hearing so much from state agencies and from the cities and towns, said, we're going to create a public construction reform commission to deal with all the turbulence out there, to deal with the fact that there's so many other states doing different types of alternative delivery. So they created a commission that was convened in December of 2003 with major stakeholders, 20 stakeholders from labor, from the generals, from the subs, from the non-union sector, minorities, as I said, state agencies, and started convening. And I know Mary Caitlin's going to talk about how that all came together and how that gelled into having one of the greatest construction reform, public construction reform initiatives of all in Massachusetts. But also Carolyn Francisco from Associated Subcontractors will be talking about the elements, specific elements of what actually was in that bill. But between December of 2003 and May of 2004, we were meeting 1 to 3 times a week. A meeting, and everyone came together and knew that this was the one time we could all bring this together and come up with a nice piece of legislation, which passed in July of 2004, a 50-page document, of which 17 pages was the AGC, ASM, and the architect's construction management at risk piece. At the same time, the road builders also, the ARPTA chapter, came up with a design build piece to put in there for horizontal work. So there's a lot more that goes into it, but I'll tell you, it was just a really good thing. Everyone came to the table knowing up front that we all had to give up something. We couldn't get everything we wanted, but we were going to bring something to the table. That what are the top 3 things you would love to see in reform?
So can I ask you a question before we move to
MK.
Mary Caitlin,
Yep.
Who's going to talk about the Reform Commission? So you are outlining here the early stages of the process.
Yep.
And I'm sure it resonates for everybody in this room. Different players need to come to the table. People need to give up something. I'm wondering, and this is for you, Bob, but anybody else can chime in and answer this as well. What triggered that setting of the table, bringing everybody to the table in a state that made them ready to compromise and, like you said, give something up and start this process moving? Because I think the most critical piece for us here now is really beginning a process in earnest. So did you get a signal from the political side, from the legislature, that this is time to go and we want you, the contractors, to get it moving? Or did this come from the ground up?
Well, this would be a perfect segue to Mary Caitlin, because it did, we were all talking about it. We'd all have to file our different pieces of legislation, but they'd all be churning. It was the legislature that convened that commission. And at this point, I'll turn it over to MK.
Okay. You're not on.
Am I on now?
Yeah.
Yes. You'll have to pardon the frog in my throat here. I'm struggling with a little bit of laryngitis, so bear with me. So my name is Mary Caitlin McSally. People call me MK, although I've certainly been called worse. As Bob just gave a great introduction as to what was happening in Massachusetts between 2000 and 2003, there were a number of different constituencies all having the same urgency for reform, but some would say had competing interests and had different aspects of what they saw reform would actually look like. And at that point in time, in the spring or summer of 2003, Chapter 46 of the Acts of 2003 was passed, which basically was a legislative mandate to form a special commission on construction reform. And if you ask, how did this all come together, I think it was critical that the legislature mandated this commission to be formed. There had been so many good intentions and commissions and studies, but then once all this good work was being done, there wasn't really a vehicle to have it actually implemented within Massachusetts and sort of to be formed to get to that point. And so what the legislation demanded of the commission and what it mandated was that it have every stakeholder at the table. And what was a critical part of it as well is it had the executive branch and legislative branch participation. The commission was made up, as Bob said, of 20 people. The governor had a designated appointment who was a co-chair, along with the House in Massachusetts. The legislature had 3 House representatives, 2 from the majority side and 1 from the minority, as well as the Senate. They had 2 majority and 1 minority representation. And the 2 other co-chairs, there were 3 co-chairs of the commission, came from the legislative delegation. So there was the governor's representative, the Senate representative, and the House representative that were the 3 co-chairs. And then there was a mandated participation by every stakeholder in construction industry, from subcontractors, associated general contractors, public owners. Public owners were required to be at the table. And the former commissioner that were from my old house, I used to be a deputy general counsel at DCAM. Former Commissioner Dave Perini was on that commission, as well as the inspector general, who was there, sort of the watchdog piece of collaboration. And as Bob said, they met exhaustively for an entire year, and the process was very much like making sausage. You know, there was all these different pieces of, you know, very good ingredients to be put in, but the process of getting there was even more complex than actually having a bill go through the legislative process, because the commission really required by the legislative act that they investigate, study, and make recommendations for possible reforms within the Commonwealth. And so it was agreed that this process had to take place, and the end product had to be a report that actually consisted of the draft legislation, if it was deemed necessary in order, or deemed advisable, in order to get to a place that reform could be initiated. And then after a year of working through this process, and as Bob said, everybody had to give up a little something to get something, there were consensus was built among the commission to put forth a piece of legislation, and it was the first and only piece of legislation in Massachusetts that was passed unanimously. And, you know, but that was really just the beginning of the process. I mean, that passed in July of 2004. I remember vividly the date, July 19th, 2004, that Lieutenant Governor signed it, because I came to work for Commissioner Perini at DCAM August 2nd, and one of the first mandates that I had was to work with DCAM on an internal basis to implement the construction reform law. So once the law was in place, you know, folks really had to focus on, you know, the discussions couldn't end there. The legislative mandate had ended. There was no continuing need or requirement for the special commission to continue to work together or continue to meet, but voluntarily, through co-chairing in the Inspector General's office, as well as DCAM, which was the largest public construction agency in Massachusetts, we commissioned a working group. And it basically was an implementation working group that had representation from many of the folks at the table here, but also representatives of the commission. And we worked together for a period of time. We still continue to work together. One of the great byproducts of this process is that walls came down and people really started to talk to each other more, and continue to talk to each other more even 10 years later, about different obstacles and issues. But we worked together to come up with, for example, DCAM was tasked with coming up with regulations for pre-qualification of subcontractors and certification of subcontractors. And, you know, there was this momentum that happened in Massachusetts following the unanimous passage of the law that allowed everybody to work together and share drafts. I mean, you had, never in history, you'd have a public agency sharing drafts of their regulatory with the industry stakeholders and getting their feedback, and actually, you know, implementing the feedback or incorporating the feedback. And so people really had this collaboration. And, you know, I don't mean to make it sound like it was all kumbaya and everybody was sort of, you know, always had the warm, fuzzy feelings about the process, but there was an underlying agreement by the stakeholders to work together and ultimately, you know, try to reach compromise, even on some smaller issues where larger issues might be an obstacle. So that went on for a period of time, and I think the other significant piece of success and why it became an opportunity for Massachusetts to really shine in this process was that we launched what were called basically road shows. And we went out, we had representatives from the Inspector General's office, as well as the Attorney General's office, and industry stakeholders as well. And we did training throughout the Commonwealth for municipalities. It was, I mean, almost every single week we had several different groups and constituencies that we went out, whether it was through AGC, ASM, public procurement officials, and really worked through that entire avenue. And one of the most significant things that, you know, did come out of it was the ability for us to use CM at risk. And by using CM at risk and sort of training people and ferreting out, you know, the private sector CM at risk that was one model, but our model was a little bit of a compromise on that because we still had to have the strappings of public procurement and other aspects. You know, we became to a place where we were educating the municipalities and working with larger public awarding authorities, some of which, like Janet will tell you, had statutory authority to do alternative procurement and do CM. And in my current house, where I'm general counsel at UMass Building Authority, we had statutory authority to do other alternative procurement and other aspects. But a lot of the larger public awarding authorities didn't have that. So there's a large education component. And what we found was that it brought more competition to the table, more CMs who weren't necessarily interested in working in the public sector were now very much involved in the public sector projects. The beginning, you know, we started having, this was before the economic downturn, we had 20 to 30 CMs participating in our DCAM projects, and now even still with my UMass Building Authority projects, we have a significant bench of firms that are interested in the public sector because we got away from, in the right circumstances, the design, bid, build process and allowed for more pre-construction and more flexibility in the pre-construction and design process. It's not to say design, bid, build isn't a viable delivery method, and we still utilize it in the right circumstances for smaller projects. It certainly makes sense. But for large, complex projects, this was a way for us to get through that process.
Mary Caitlin, before we move to Carolyn, could I ask you just a quick question about the commission? Who staffed the commission, I'm wondering, and also who staffed the implementation working group? Because that's often there's a big failure that happens between, wow, we passed that legislation, we're done, and the idea that you put in this implementation working group sounds to me to be critical, as you point out, to this process. So I'm wondering where the staffing came from, who staffed it, who funded the staffing, little things like that.
There was limited staffing. So the legislative contingent had their staffing as far as helping to draft, and their legislative staff worked on drafting and editing and working with the various constituencies. But as far as implementation, it really was out with the commissioner, with the inspector general, with all of the even executive level stakeholders were out doing the training and doing this really to convey the importance of it to the industry and the commitment that they had from the industry. As far as the back channels, I can remember many late nights drafting regulations and working directly with Bob and John and other folks at the table, and ASM, Monica Lawton, and all different, really going through wordsmithing everything. So it was a very tedious process that, there wasn't a lot of staff to get it done. And the expertise, because it was so important, the expertise that the folks that were on the commission brought to it, they also brought a commitment to see it through. So that's really a unique aspect as well.
Thank you. So Carolyn is going to speak to us about the actual elements and safeguards in the 2004 reform legislation as it applied to the alternative system of delivery.
Hi, folks. I'm Carolyn Francisco. I am counsel to the Associated Subcontractors of Massachusetts. I'm going to talk for a few minutes about some of the key elements of our statute. But before I do so, I want to, highlight the goals of the reform effort. So going in, the Commission sought to increase accountability, provide more flexibility in procurement, and enhance competition, all while preserving our core values of our competitive bid law. There were pros and cons of the design bid build system, and depending upon who you speak with, some people loved it, more so subcontractors, and some folks didn't like it. But all agreed that there were some core values that they wanted to see implemented in a CM at risk procedure to secure a competitive, fair price for the taxpayer among responsible contractors, to maintain an open and honest procedure for competition, and to maintain equal footing for all bidders. And it's with those goals in mind that the pens came out and the drafting began. With respect to applicability, our CM at risk statute applies to building projects with an estimated cost of $5 million. So as Mary Kate mentioned, it's not for the smaller jobs. You have to at least be that $5 million threshold. Now, the task force and the folks who were drafting the legislation recognized that this was going to be a big change for Massachusetts. I mean, some of our most earliest versions of our competitive bid law date back to the late 1930s. This was going to be a bit of a shock. The procedures for contractor and subcontractor selection were going to be different. The method of establishing a contract price was going to be different. Costs and accounting were going to be different. And they also recognized that not all awarding authorities are alike, right? So some have the exclusive job of building. That's what they do all day. And they have a very experienced, sophisticated staff that manages their construction. Then you have the awarding authorities that are lucky to maybe build a school once every 20 years. Okay? So it was with that in mind that the drafters of this law provided some safeguards to ensure that we're not just going to throw this new law out there at some very inexperienced awarding authorities and have them fend for themselves. One of the provisions in the law, which is a little bit unique, is we have two categories of awarding authorities for some selected purposes. We have exempt agencies and everyone else. Okay? The exempt agencies are 5 awarding authorities that do a lot of construction and do it quite well. They are DCAM, or Division of Capital Asset Management and Maintenance. They are the Massachusetts Port Authority. They are the Massachusetts Water Resources Authority. They are the Massachusetts State College Building Authority. They are the University of Massachusetts Building Authority. So they recognize that they're not going to need maybe as much hand-holding as some of the other awarding authorities. One of the safeguards in the statute is a very important and prominent role of our Inspector General. A threshold to using CM at risk is as follows. All awarding authorities, except for the exempt agencies, must secure approval from the Inspector General to use the CM at-risk delivery method. They do so by submitting a very detailed application. They must, and it's not an easy hurdle by no means, they must satisfy the Inspector General, among other things, that the awarding authority's goals and objectives for utilizing CM at risk are reasonable and designated to maximize competition. Remember that goal. That the awarding authority has an established and experienced and effective project organization structure to administer CM at risk. That the project team members have relevant CM at risk experience. The Inspector General wants to know that there is a plan and procedures in place to demonstrate that there is an appropriate assessment of the owner's tasks and the responsibility of the CM. The Inspector General inquires as to whether the owner's plans and procedures have an adequate framework for conducting a 2-phase selection process, and it goes on and on. Since 2005, our Inspector General has approved, according to the website, over 84 applications for about $4 billion worth of construction. Now, another safeguard. Prior to submitting an application to the, let me say one other thing. The exempt agencies, so what do? They are not required to seek approval from the Inspector General on a project-by-project basis, but rather, on an annual basis, they submit their procedures for the administration of their CM at risk projects to the Inspector General. And so long as those procedures are consistent and compliant with the statute, the Inspector General approves those, and then those awarding authorities can use the CM at risk delivery method at their discretion. So once a year they submit their approval. It is not the type of rigorous review as with all other awarding authorities. Now, another protection to ensure that our awarding authorities who are procuring under CM at risk are ready for this process is our awarding authorities must hire a OPM, an owner's project manager. And that owner's project manager is actually hired prior to the application that's submitted to our Inspector General, prior to. So that OPM is hired to help the awarding authority put that application together, as well as, under the statute, they act as the owner's agent and consultant. They're involved in the planning, design, procurement, and construction phases. The OPM, under the statute, must have a certain level of experience. The OPM must be a registered architect or engineer with at least 5 years of experience with similar projects of size and complexity, or if not a registered architect or an engineer, at least 7 years of such experience. Also, prior to the submission of the application, the owner also hires the designer. So the owner is putting their team in place before they even receive the permission to go forward. That education and that training process begins at a very early stage. There are procedures in place in the statute to ensure that qualified and responsible CMs and trade contractors are performing the work. With respect to CM selection and trade contractor selection, it is a two-phased process. There's a pre-qualification process and a proposal or bidding process. With respect to pre-qualification, the CMs, an awarding authority assembles a pre-qualification committee, and the statute says very specifically who is to sit on that committee. A detailed request for qualifications is issued by the awarding authority, very detailed with certain statutorily required information. Public notice is provided of that RFQ. At least 3 CMs must be pre-qualified. Again, competition, 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 help bring in reasonable prices for the taxpayer. If an awarding authority is unable to pre-qualify 3 CMs, they either can go out and resubmit the RFQ to receive further requests for pre-qualification, or they can abandon the CM at risk model and go to a traditional design bid build. Okay? But our statute wants to see at least 3 CMs pre-qualified. Now the proposal phase. Again, a selection committee is assembled. Only pre-qualified CMs may submit a proposal. The awarding authority prepares and issues a very detailed request for proposals, or RFP. The committee then ranks the proposals. They rank the CMs from the highest to the lowest. Non-fee negotiations begin with the highest ranked CM. If the awarding authority determines that a contract will likely not result from any further negotiations, the negotiations are terminated and the awarding authority moves down to the next highest ranked CM until a CM is selected. That's critical, and that was very purposeful that the negotiations terminate and they move on to the next CM. So we're protecting prices, we're protecting proposals, and we're not having a bid shopping, one pitted against the other. With respect to the trade contractors, so our CM is now on board as a result of the two-step process. The selection of trade contractors is, as Bob mentioned, modeled much after the filed subbid law. Subcontractors like the filed subbid law. There's no secret about that. And so their representation on the commission was to preserve as many of the core values and aspects of the filed subbid law. We gave up some, but we got others. As Bob mentioned, there are 18 classes of trades that are carved out as trade contractors. They're called filed subcontractors and design bid build, trade contractors on the CM at risk side. This was new and as a result of the reform effort. Trade contractors are pre-qualified under a highly detailed process that the statute sets forth. The statute sets forth the criteria in which the trade contractors are judged and the point system in which the trade contractors are judged, and even the score that they must achieve. They are pre-qualified by an awarding authority pre-qualification committee. Only pre-qualified trade contractors are allowed to submit bids. The second phase is the submission of bids. Rather than proposals, trade contractors submit bids. An awarding authority issues requests for bids with very detailed information as to their scope of work. The CM is very involved in the drafting of that RFB, and as Bob mentioned, the scope of work. That was a big change and difference, and one that the subcontractors in Massachusetts recognized needed to happen for CM at risk to work. On filed sub-bid side, subcontractors bid based upon the plans and specs, period, paragraph. We have actually even mandatory provisions in our law where a filed subcontractor's work must be detailed in separately segregated specification sections. Okay? Subcontractors enjoyed that, looking at their own plans and their own specifications. Now on the CM at risk side, those plans and specifications are now supplemented by scope of work documents. We call them Exhibit B documents, which the CM assists in preparing to further define that trade contractor scope of work. The trade contractor submits a sealed bid that is publicly opened. As a general rule, the lowest pre-qualified trade contractor is awarded the job, of course, provided he submits a compliant bid. That trade contractor then enters into a contract with the CM at risk, and as Bob mentioned, that is a statutory form of contract that is also modeled after the statutory form of subcontract on the design bid build side. So in substance, it's and this is just we could do 4 hours just on the procedure. This is a very brief overview of 2 steps for both the CM and the trade contractor. Our CM obviously, like CMs on private work, has a very detailed statutory role. On the pre-construction side, obviously a CM advises and awarding authorities on issues relating to design and constructability, schedule, etc. On the construction side, the CM wears more of a GC hat. The CM holds the subcontracts. The CM is responsible for the construction pursuant to the plans and specifications and all of the construction services. We utilize a cost plus, not to exceed GMP form of contract. It is an open book process. The awarding authority monitors and audits all costs. CMs under our procurement method are not entitled to share savings, but an awarding authority may include incentives for various performance obligations like completing early. The GMP is based upon design documents that are at least 60% developed. Once the GMP is agreed between the CM and the awarding authority, it is executed and added as an amendment to the CM at risk contract. That amendment must be executed prior to commencement of any work, with one exception. An awarding authority can let out early packages so long as there is a separate amendment for that work. Much like private work, and our statute is very, very specific, that GMP amendment must include very specific things: a line item cost breakdown per trade, CM contingency, GCs, fees, list of plans and specs on which the GMP is based, allowances, assumptions, etc., etc. Other safeguards or procedures that were carefully and appropriately included in our CM at risk legislation. Our CMs and trade contractors all must provide payment and performance bonds. Our trade contractors must provide a bid bond to bid. Our CMs and trade contractors are not only pre-qualified by the awarding authority, and that was very important for our cities and towns, because under the design bid build system, low guy gets the job. And there was no, at that time, any other type of pre-qualification of subcontractors. Now under CM at risk, not only are they pre-qualified by the awarding authority, they must be certified by DCAM. Prior to CM at risk, only general contractors were certified. With construction reform, they added that requirement for trade contractors. So you have 2 levels really of review. And again, remember, we're looking for competitive prices from responsible contractors. Most or many of our laws that pertain to design bid build were also incorporated into the CM at risk method: prevailing wage, laws governing payments to contractors and trade contractors, record-keeping laws, laws regarding finality of designers' decisions. They were all incorporated by reference. Another new element that, again, I think really the goal of accountability, this hits that one. We now have required project evaluations. So now trade contractors and CMs and general contractors are evaluated. They get a score sheet. And by statute, if they get so many failing grades within a particular period of time, they may or shall be decertified. Okay, accountability. Remember those goals, accountability. So those scores go to DCAM and they are in the folder, and hopefully they're all very, very good. Our Inspector General, to Mary Kate's point, the folks on the commission and on the task force spent a lot of time training when this was rolled out. That training hasn't ended. And our Inspector General plays a very important and prominent role in that training. On the Inspector General's website, there are very detailed guides and manuals for procurement, both design, bid, build, CM at risk. They also run one-day training courses. There are links to various model contract forms, etc. So our Inspector General is not only serving the role as gatekeeper, but continuing the education process, which is so important. There are awarding authorities today that are doing CM at risk for the first time. And finally, the final safeguarded procedure is our Attorney General also plays a role in our public procurement process. Under the design, bid, build, and under CM at risk, our Attorney General is empowered to hear bid protests. Those are non-binding advisory opinions, but in a very quick, effective manner, folks who are not happy with either being rejected or the selection of another contractor can go in and have a bid protest heard within a matter of sometimes 10 days. And most awarding authorities, although it's a non-binding decision, will comply. So we also have, someone who's out there overseeing the procurement process and ensuring that the laws are followed.
Thank you.
Questions?
I'm going to hold my question for you till afterwards and move on to Janet, who's going to talk about benefits and advantages of the CM at R alternative from the agency's perspective.
Great. I'm with the Mass State College Building Authority, and I will tell you how we utilize CM at risk, and hopefully I think you'll hear that everything is pretty much in line with what Carolyn just outlined. But we build revenue-funded facilities on the state university campuses in Massachusetts. We build predominantly residence halls, but also dining halls, parking facilities, student centers, anything that can be funded by debt from student fees or rents. We have an excellent reputation. I think that's why people in our state seem to ask us again how we do it and how CMs and designers really enjoy working with us, and they'd like to work with us again in the future. Our client colleges are very happy with us assisting them, and we really think that we're special. Everybody does, right? But our projects cannot be a day late. We are building residence halls on occupied student campuses. It's like the tide coming in on August 15th. If the project's not open, they're moving in anyway, and that's the bottom line. I mean, you can think about putting them up in hotels and so forth. There's not enough space any place to take care of 300 students. From a budgetary point of view, we receive no appropriations. Every dollar is from student rents. If we were to go over budget, there's no rainy day fund or no override that we can seek. So the budget is critical. And then the quality, of course, these projects, they might be the only project on the campus in 10 years. So the project may have to do a lot of things. Maybe it's a gateway to the campus. It needs to be something that's going to facilitate recruiting new students, retaining those students, maybe assisting with some space for commuters. So it really has to be a quality facility that has to last like 100 years, because these universities and institutions don't have the funds to take care of extraordinary expenses. Although we do fund in our project pro forma a renewal reserve, so that just puts an added little strain on the budget too. So all of those three components have to be taken into account. And that's why we did have special legislation even before 2004 to be able to bring a team together and get these projects done by people that have built residence halls before and work together and make sure that we have the right team in place. But during construction reform, my executive director, Ed Adelman, and his predecessor did make sure that our procedures were codified in the new legislation. And so we have been doing CM at risk now since 2004. Since that time, we've probably put $1 billion of construction in place, just in round numbers. About half of that is new construction. Maybe a quarter of that is our summer renovations. So because we have so many small projects that we've done in those 10 years, we really feel like we've road tested these procedures and the statute. And we have not only a lot of practice, but also we have had the ability to go back to design bid build if that should be warranted. And we, as Mary Caitlin said, we do use design bid build for small projects, especially the one trade straight, like a roof renovation or electrical upgrade or something like that. We have our own legislation that is for projects over 1 million, so we are able to do that on lots of projects. Our project teams that we put together, we use the procedures that Carolyn outlined, but we expect them to be very autonomous teams. They need to be fast on their feet, they need to deliver, and as I said, we really attract the best firms in the Boston area. I think the designers are very happy to be sitting on the committees by statute. They are on the selection committee for the CMs, and I think that makes them more amenable to be part of this process. And then the CMs are also, who may have been reluctant to work in public construction before because of the filed sub-bid rule, maybe it was something not familiar to them, they are comforted by the fact they are able to participate in the pre-qualification process. And in fact, they are probably most qualified to help evaluate the firm's financial capabilities, their capacity, their current workload, and we really do expect them to be part of that. And so I think that's why we do attract the great firms. Just an aside about the trade contractor pre-qualification, we take this very seriously. We take it on. It's like a sport every fall. Our projects are pretty cyclical. Most of our work happens in the summertime, starting in March, we start our new projects. So we do most of our pre-quals this time of year. Even though we run the pre-qual process from an administrative point of view, all of the project team members are very active, the OPMs, the architects, the CMs, and it's a very engaged process. And we don't really consider it a hardship. These are the people that we work with all the time. These are firms that are doing all of our construction work. But the contract is with the CM. So we take the bids, we open them in our office, but then the contract is to the CM. It's one of my pet peeves when our CMs will say, it's one of your contractors. I'm thinking, no, it's not one of my contractors. It's your trade contractor. But I think by and large, the projects have a true spirit of collaboration. As we work on these projects in the very beginning, the CMs are there usually from the study phase, if not from the beginning of schematic design. And by the time we get into the point in the project where we need to look at some value management ideas, et cetera, we're all working as a unit, and everybody really cares about that project budget as if it were their own money. Maybe there are different reasons for motivation, but if the project is over budget, it may not go forward. Everybody is motivated to keep the project moving. We do a series of estimates on every project, and I think this is one of the biggest advantages to CM at risk is the budget certainty. Because we have limited dollars, or the dollars are finite anyway, we know about the budget as we're moving along. Everybody in the team is helping to scope that project with our college clients, and we have a series of estimates at every different phase of the design, and we have third-party estimates as well. So we're tracking right along the whole time. We know exactly how much it's going to cost before the bid documents go out. There may be a little bit of discussion about how much contingency we should be holding at different points during the process, but we're all in it with our eyes open. Also, another advantage is the time to market. The fact that the solicitation's already been done, but before we get out to the bid period, we don't have to spend another 4 or 8 weeks to get a CM or a GC on board. And also, we have their input as far as when to release a steel package, what the pricing is looking like, what the market volatility will be looking like. And we expect the CM's input on quality issues. They're very adept now at helping us with systems, with building controls, with site conditions, the supportive excavation, all of the special conditions on every single project, and even on structural systems. I mean, I really wouldn't even want. I wouldn't want to do a project without having the CM weigh in with the structural engineer as to how we're building the building. It may be a good project for a precast or a block and plank building or a steel or hybrid system, but it's really great to have their input. As Carolyn mentioned, there are no shared savings on these projects, but we do offer incentives in our contracts anyway, and those are a really good motivator. Both the designer and the CM are looking forward to getting their bonus, and they're kind of shared milestones, so that keeps both parties on track to try to meet the delivery dates and the design milestones. But they're also, I think the bonus is also, we've seen it used as almost like a relief valve. We don't have a lot of claims on our projects, but if we're getting towards the end and there's a design miss, it's not that unheard of that the designer would use his bonus money towards a redesign of something or to mitigate a defect in the process. So I don't think, I can't really speak quantitatively about if there are less claims. I just know that we don't have any outstanding claims. We do have occasional bid protests, and they're usually on minor informalities in the bid process, but we don't, at this point, we don't see any on the major construction contract because we're already set with who's building the building. So we don't see a delay in that type of thing. And then people ask me if it costs more. All I know is that we build a lot of residence halls, and we're pretty much at the same benchmark on every project. Yes, there are pre-construction services, but that's pretty short money in the scheme of things, and you're really getting a lot of benefit, like you would with any consultant in the process, probably about the same amount I'm paying for a commissioning agent, I'm paying for pre-construction services. So I certainly think that's worth it. There are, I guess you might call it a downside. There are a lot of responsibilities in an open book contract. The owner, once things are opened up, your eyes are open, the more you see, the more you know you need to see even more. So there is a little bit of work on that side, but I think that that's balanced, offset by the risk, the things that we don't see in with a straight design bid build process, where you don't know what the bidding pool will even be. You don't really understand what their markups were. Was the design package complete? Did everything you want get into the design package? And even worse, maybe you're buying more than you even needed. So I don't even know if you can really compare this, on a project-by-project basis to find out if there is a cost benefit. But I think that the scale really tips a lot more to having the budget certainty and the schedule certainty. The other thing is we have found that the CMs, I hate to sound like an advocate for CMs, but we find them to be more of a partner, and they bring to the project analytics. I think one of the other panels talked about lean processes. They bring lean principles into the project. We have one of our new high-rise buildings in downtown Boston where after the bidding with trade contractors on board already signed up, they implemented lean on into the project, and it was really wildly embraced by the trade contractors and subcontractors in the project. We were definitely early and on budget, and I think that all of the subs and trade contractors probably made out pretty well by implementing the lean principles. The other thing they bring is the MEP coordination and the BIM coordination. They are currently, on our projects, they are co-locating with designers, and they are also expanding their role during the warranty period. So I think from my experience that to be able to include these things in design, bid, build package would be very difficult, maybe possible, but I really don't see how it would be done easily. And I think the analogy of the tools in the toolbox is quite apt. But I think there's also a lot of the things, I guess the trappings of public procurement is almost like the accessories in the toolbox, and to be able to know how to use them and use them effectively is really important. And then also to not let those trappings create such a like too much process or too much bureaucracy. So I think that's my story.
But that's extremely helpful, and I know the emphasis that you placed on the budget and schedule certainty will certainly resonate with anybody in the public sector who has had to bring a building contract to fruition and finds themselves not just days and months behind, but years behind on most projects. So I think that's just a really important observation. And just a quick question for you. As somebody representing a government agency, is there anything about quality that you can speak to? I know we all have to be concerned with budget and scheduling, and I'm hearing a lot about everybody who's working with government seems to be happier, which I think overall makes everybody happier. So I'm not giving that any short shrift. But from your perspective, are you getting a better? I know this is a very general question, but see if you can handle it. Are you getting a better product from this process? Something that you knew what government, as the representative of government and the people, that you wanted, and this is a better way of achieving that.
I think so, because I think we're, first of all, we're spending more time with educated people making the decisions about what it is that we want. So that's critical.
Okay, that's very helpful. We're going to move on to John, who's going to provide us the designer perspective.
Good afternoon. My name is John Unry. I'm the Executive Director of AI Massachusetts. I'm just going to focus on sort of 6 areas. OPM's versus designer's role, the applicability and advantages of CM versus design bid build, how have municipalities handled the process, is the CM process too sophisticated for most local building committees, should New York State limit the experiment to just state agencies, and how has the role of our Inspector General as a master gatekeeper worked? So starting with that, talking about the OPM versus designer. Just a little bit of context, building on things you've already heard from Bob and others. Back during 2003, 2004, when construction reform was occurring, there were a lot of projects in Massachusetts for a variety of different reasons that were coming in over schedule and over budget. That was one of the major impetuses for construction reform, to try to figure out a way to resolve some of these problems. And at the time, there was the beginnings of what kind of became a poster child case of a high school project down on the Cape, where at the time there was an architect who had been fired from the project for a variety of different reasons. The project turned out to be about $19 million over budget, about approximately 3 years over schedule. The town fired the architect, hired another, went through the project, and at the conclusion of all that, there was a court case. The architect brought the town to court, and the architect won, and was awarded a settlement because the prosecution couldn't show that the architect had deviated from a normal standard of care. But that court case came many years after we did construction reform. So just to give you the context, there was a concern out there that projects were running amok, and the people that were currently in charge maybe weren't the most qualified. So that led to a discussion about creating an owner's project manager, or putting a requirement in place on all projects for owner's project managers. So that is actually what happened. We put a requirement in place. So owner's project managers are required on all projects with an estimated construction cost of $1.5 million or more. As was mentioned, they can either be a licensed architect or a licensed engineer with 5 years experience. And if you're not a licensed architect or engineer, you need to have 7 years relevant experience. Obviously, the OPM is hired before the designer, serves as the public agent or as the public agency's agent, and consultant throughout the planning, design, and procurement process, and includes construction. The agency may assign those duties to an employee if they meet the qualification requirements. The OPM must be independent of the designer, so you can't hire an OPM who is also the architect, and can't be a general contractor. So the GC cannot also be the OPM. And the OPM selection process is a qualification-based selection process. So that's kind of gives you the basics of what the requirement for an OPM is. Obviously, I represent architects, so our largest concern at the time was that OPMs were really being brought on to take over some of the duties that architects had always traditionally performed. Clearly, one of the justifications that was used turned out to, in hindsight, not really be one of the, not be an issue. I'll put it that way. One could argue that now designers, although we're part of a team, might be viewed more as just consultants now, where the OPM is really just running the project. It's been my experience so far that's not really the case, but that certainly was the concern. Whether that's the case or not, the reality is in Massachusetts, that's the law. That's what we have. It's not going to be going away, and there hasn't been any attempt to try to do away with the law. But that said, and as was mentioned earlier, we have all continued to keep meeting since 2004. And there has been agreement more recently about putting a little more constraints around what an OPM does, what their services are, what they actually should be responsible for. And at our most recent, what was called a construction law working group, we came up with some issues that needed to be addressed. And some of those issues were legislative, some of them were regulatory. And at least on the regulatory side, DCAM had agreed to try to start addressing some of these issues. So some of the issues that got brought up were whether state agencies should certify OPMs before they can work on public projects. There was development of a standard scope of services and guidelines for OPMs in contracts for all public projects. Should there be changes in the law to establish an OPM evaluation process, much like that of the process that's used for designers and contractors and others? And lastly, should they encourage and require OPMs to work more closely and be more involved with owners in the evaluation of contractors? What was eventually agreed to were some administrative and regulatory changes that encouraged and required OPMs to work more closely and be more involved with owners in evaluating contractors, and to better define the OPM role in public construction. Now, that second one really is more of a legislative fix, which unfortunately the agreements that we all came up with, that legislation never actually saw the light of day. So at least on the regulatory side, DCAM has made a commitment to work to get the contractors more involved in, or the OPMs more involved with the owners in evaluating the contractors. Now, from our point of view, all this said, our largest concern hasn't really been the issue of OPMs versus designers in terms of a turf battle. That's really not what we're concerned about. Really what the issue to us came down to was an issue of cost. OPMs, for the most part, are paid a fee, which is generally about 2 to 3% of the overall project cost. And what our concern has been is, let's say it's a $50 million project, that equates to about $1 million in fees. Without a conversation about taking $1 million now out of the building that you're proposing and finding a new way to put that $1 million back in, our concern was always that we've added another layer of oversight, which is never a bad thing, but that layer of oversight is coming at the cost of less building. $1 million could be the difference between a 2-pipe system and a 4-pipe system. From our point of view, a 4-point system would be much better, but if you take $1 million off the table from the very beginning, that's not a conversation you can have. So that's really what the concern is. That's what, if it's something New York State is considering, I would strongly urge you to consider thinking about if it's a layer of oversight that you'd want. Consider that you also want to figure out a way to find that money to go back into the building projects. Applicability advantage of CM versus design bid build. We've talked a lot and you've heard a lot today about the various processes we use. We have various procurement processes at varying dollar thresholds for a variety of different construction projects. I'm just going to focus for the most part on vertical construction. Most of that work falls into the threshold of over $100,000. If your estimated construction cost is over $100,000, you use a certain process which includes the file subbid system. The CM at risk is available for construction public work projects estimated at over $5 million, and those processes have been talked about. The differences between CM and risk at design bid build, pretty simple. Design bid build is a more traditional approach. Architects, consultants get together, they design the entire building, project is bid, you receive your file subbids first, then your general contractor bids. The general contractor puts in a lump sum for the estimated construction cost, and you sign a contract and off you go. CM at risk, I won't go through that entire process again, but I will bring up one thing that I think is important to talk about, at least with the CM at risk in terms of the GMP. It was mentioned that what our state law requires is that you cannot negotiate your GMP before you hit the 60% construction document point. What wasn't talked about, and I think it's an important thing to remember, at least in Massachusetts, is that if the CM and the owner do not come to a fruitful negotiation on the GMP, the owner can then go to the second selected CM and try to negotiate a GMP with that CM. Failing that, the entire project reverts back to a traditional design bid build project. So in theory, you're already 60% into CDs, you haven't really lost anything, you've gained the benefit of having pre-construction services, but with 40% left on CDs, you can finish those drawings and do a traditional design bid build where you'll do your file subbid and then general contracting bid. So to talk about the advantages of CM over design bid build, obviously some of the things that were talked about, you get the pre-construction services benefit that you don't get in design bid build. The CM GC is participating in cost estimating, in value engineering exercises. They're there for constructability reviews. They're there to help you schedule the project and help prepare the file subbid packages. They're able to start construction sooner. So as was mentioned earlier, you can do early footings and foundations. You can do early steel. You can reduce your construction schedule by getting in the ground quicker. Advantages of design bid build over CM at risk, quite frankly, we haven't proven, as has been said, that it costs more, but the reality is I would say it's cost. When you're using design bid build as opposed to CM at risk, the owner's not paying for pre-construction services. And when you're doing a CM at risk project, you are doing a GMP, and because the GMP is based on, at a minimum, 60% design documents, there will be contingencies that are built into that GMP that are not built into a traditional design bid build estimate or bid. So you have to decide for yourselves which is better or which is worse. That sort of leads into the question about how have municipalities handled the process. And what I have found is that it really just depends on, one, the level of experience in the community of either the elected or the appointed building committee that's going to be in charge for the owner, two, the level of experience of the OPM and the architect that are on the project, and three, the complexity of the project. Prior to taking my job, I worked for 15 years designing and building public schools in Massachusetts. And what I noticed was that the more sophisticated building committees, or the more the sophistication within the building committee, the more there was an openness to look at CM at risk as opposed to design bid build. Now again, that's just my personal experience. Once the OPM and the architect are on board, they have the discussion with the awarding authority as to, for that specific project, what is going to make the most sense. Is design bid build better or is CM at risk better? I will just share with you my own personal experience. I chair my town's building committee. We do have a capital plan. We just had a ribbon cutting 2 weeks ago on our brand new $9 million DPW facility. The second project in our plan is a brand new $14 million police or public safety facility, which we will go to a town meeting in March to ask with bids in hand for that money. And in our building committee meetings, we had the discussions. Should we do this at CM at risk? We have an existing building. Half of it is police, half of it is fire. We had a police chief who, prior to working in our town, worked at another town and went through a construction project of a new police facility and was adamant that he did not want to move. He wanted us to, because we're building the building in the exact same place that the existing building was, and because there is actually fire separation between police and fire right now in the existing building, he said, I want to stay on site. I want you to tear down half the building, build the administration half. I'll move in there, you'll tear down my building, and then you can build all of the apparatus bay. And we looked at that. And quite frankly, what finally sold him on the idea of not doing CM at risk was he realized he was going to have to continue his police operations in the middle of a construction site. And the thought in his mind was, most people that ride in the back of the cruiser don't really want to be there. And when they get out of the car, they're not happy to just walk inside. They might be a little ornery, let's say. And what the police chief was concerned about was, I'm taking this guy out in the middle of a construction site. What happens when he falls down and lands on a piece of rebar or smacks his head on the side of an I-beam? So he quickly said, nope, I don't want to do it. And we as a committee decided CM at risk is not appropriate for this project. We went design bid build. But as I said, we have a capital master plan. Our very next project, which we will likely go for designer services in the fall, is a brand new elementary school. And there's very little doubt that we will use CM at risk on that project. It happens to be right across the street from the new police fire facility that we're building. So again, it just comes down to, project by project, what makes the most sense. And again, anecdotally, we know that CM at risk costs more, but the reality is there are a lot of benefits that outweigh that additional cost that may come with it. So that'll lead me into, should New York State limit the experiment to New York State? And as I've sort of understood it, and as others have said, I think that's kind of the way we actually did it in Massachusetts. The State College Building Authority, although they weren't doing traditional design bid build, sort of had their own version of design bid build before we had it in Massachusetts as state law. I know DCAM became the earliest adopter of it because they had knowledgeable in-house staff that knew what this process was. Municipalities, I would say, were a little slower to adopt it for a variety of reasons, which I mentioned before, but as time has advanced, more and more they appear to be using it. And certainly in school construction, it seems to be the way to go these days when doing a school. So at the beginning, when we passed construction reform in 2004, the reality was OPMs were brand new. They didn't know a lot about it. Architects, some of them knew about it for those that did work in other states, but other states' CM at risk laws were different than what we passed in Massachusetts. So there was a learning curve that needed to happen. And also, again, as I mentioned earlier, the sophistication level in the building committees, in the municipal building committees, wasn't necessarily there. So it would be my opinion, at least, that if New York State were to consider putting this into state law, that it would be open to all. But what I would suggest, at least, is that you consider it as a phased rollout. You start with your state agencies. As MK talked about earlier, let them start the process first. They have the in-house staff that's going to understand this. They have the ability to do these things. But at the same time, you're working with the municipalities to help educate them as to what this is and how it might work. The time frame for the rollout obviously would be something you would all have to determine for yourself, but that would be my suggestion based on what I've learned. Lastly, the role of our state's inspector general as the master gatekeeper, has it worked? It's been talked about earlier that you have to go to the inspector general to get approval for the project. And I'll just quote out of the 2009 inspector general report what their experience was, which was, quote, all owner representatives interviewed for this study who were familiar with the OIG application process for their CM at risk projects expressed satisfaction with the application process. Some owner representatives characterized the process as straightforward, user-friendly, and reasonable. One owner representative noted that the OIG had provided helpful comments on the owner's preliminary application. None of those interviewed recommended changes to the application process. So I think it's been successful. Again, thinking out loud, and this is only through hindsight, my suggestion would be that, again, if you're going to consider something like this, having a state agency as sort of a watchdog to make sure that it's being used properly, what I would consider, and it's something we don't have in Massachusetts, is a sunsetting of this requirement. So in Massachusetts, we have it right now in perpetuity, but one could argue that we've become so good at it that the municipalities know how to use it now that to a certain extent, why would you need to go to the Inspector General's office at this point to ask for permission to use it, when the reality is owners, project managers, architects, contractors, we all know how it works now because we've had 10 years of experience with it. So that would be my suggestion to New York State.
That's extremely helpful. I have several comments on your remarks, but I'm going to hold my comments because we're kind of running late here, and I really do want to hear about the lessons learned from Stan. I know everybody's actually addressed the lessons learned issue. I would just make one point, which is, we have a city of 8.4 million people with extraordinary capacity to implement this quickly, and I think if the state legislature passed this and said, we're going to have to wait, 5 years to do this in New York City and even Buffalo or Syracuse, I think the mayors and business folks would be very unhappy waiting for the state to roll out their piece. So from a political point of view, I think we might want to move more quickly on something like that, even though I understand why a sort of rolled out approach is being advised. But having said that, just taking the prerogative of the moderator here, I'll move on and let Massachusetts wrap up its remarks.
Okay, thank you. My name is Stan Martin. I'm going to talk about the lessons learned. As the next to last panelist on a panel that's running behind, I suppose I could discharge my obligations by saying, great, it's going really well. But you might want a little more detail. I'll give you a little bit of detail. 5 years ago, the Inspector General wrote a report. This is still available through the IG's website, even though it's 5 years old, and they only had a limited number of completed projects at that time. They focused on 8 projects primarily. It's still some useful information that I think is still pertinent. There's no real data statewide, but we have a lot of anecdotal evidence, and I want to get into that. I don't think anybody views this as a cost savings program. What you are looking for is a better process leading to a better quality building overall. And I say overall because the subcontractor who's laying concrete floors may be doing the same quality of work under a filed sub-bid job or a CM job, but I'm talking about coordination of the overall process. Janet mentioned the residential hall for can't believe I'm drawing a blank on Mass Art, where my wife is an alumnus, but Mass Art, it's being held as the example for lean building in the state. My personal opinion is it never would have happened under a filed sub-bid process. Never would have happened. I think there is better delivery of value. There is an interesting comment in the IG's report. They interviewed 8 different public authorities, and one of the questions they asked was, were you satisfied with the caliber of the firms competing for your projects? And 8 out of 8 said Yes. I think that is a fundamental difference that we have seen in Massachusetts. It was one of the things that led the Mass Municipal Association, many of their members prior to this legislation, looking for one-off special legislation. They were unhappy with the caliber of contractors who were competing for their work. A lot of the reputable contractors had decided to stay away from filed subbid. This was a way of getting them back into the marketplace. They are not entirely, but predominantly larger contractors. They are often union contractors. They have great reputations. They will come into the market and compete for the CM projects where they had not competed for the filed subbid projects. So I think we're getting better quality contractors competing for the work. We're getting the benefits of the CM process that the private sector has long known about, which is the contractor input into the design while the design work is still ongoing. So you not only get constructability reviews, you also get comments on how to divvy up scopes of work, how to allocate work among the trades relative to even trade union agreements. Many of these contractors have the knowledge and sophistication to identify where you can shift things from one from something that might often be considered as roofing, you might shift it over to miscellaneous metal scope of work and do better, or vice versa. They have that expertise, that knowledge base. They can provide these recommendations during the design process. I think the design and construction process, historically, what we've seen on the CM projects is it flows more smoothly. Are there problems? Yes, I think many authorities, particularly cities and towns, who aren't doing this on a regular basis, are not ready for the level of effort required of them up front in the pre-qualification process and in the interaction between design professional and contractor. It takes a lot more involvement by the awarding authority to be part of that process and to manage the process. I think that was one of the early complaints that Mass Municipal Association and the IG were getting from some of these cities and towns. Oh my God, we didn't realize, our building committee had no idea how much time this was going to take. So that's one thing that they need to be aware of. I think there are lots of benefits from that, but that's one thing they need to be aware of. Another concern has been expressed about whether the CM ends up with a little too much control going into the GMP process. You know, John spoke about the ability of the public authority to jettison, and actually MK spoke about this as well, jettison the top-ranked CM and move on to the next one. We did see that happen with the city of Methuen, town of Methuen, I guess, on a public high school project. They were pretty far down the road with their CM, and they just couldn't reach agreement on the GMP. There was a difference of opinion on a lot of assumptions that were layered into the estimate, and the town went out, and they had 3 competitors originally. The second-ranked competitor actually said, no, thank you. Timing no longer works for us. They went to the third-ranked competitor who jumped in, took over the project, and I think it's been a very successful project. So this can work. It may have some bumps in the road, but it can work, and I don't think owners need to be aware of ceding too much authority to the construction manager in the process. There have been perhaps some misunderstandings. It's embodied primarily in one lower court decision that came out 2 months ago as to the level of responsibility of the construction manager relative to design. Subcontractor files a lawsuit alleging extra work arising out of the design, files the lawsuit against the CM. The CM, third parties, the public authority, saying, if the sub is right, that this problem arose out of the design, then I have a claim over against you, the public authority, because you hired the architect. A lower court judge threw out the third-party claim, saying, no, the CM took on a larger role in design, and we think the terms of the indemnity in the prime contract mean that the CM actually has to protect the owner against these subcontractor claims. I have no involvement in this case. My firm has no involvement in this case. My personal opinion is the judge did not have the full level of information in front of him in his decision. Yes, the CM plays a bigger role during the design process. No question about it. All these CM firms market that in their marketing materials. They do play a bigger role. But that doesn't, I think the judge took it one step too far in saying, as a result, they bear the responsibility if the design is not working. Bob, I don't know if you mentioned this or not, but AGC is looking at some clarifying language in the legislation. The particular decision is up on appeal. There's been a lot of interest in that because there's a lot of concern that this is really the first case to go up under the CM statute on appeal on any issue. And people would like to feel that as an industry, we're getting it right and not leading to any kind of fracturing that might be a bad sign for the industry as a whole. Got lots of different players with lots of different interests. But I think on balance, it's been a good thing for the state. I think some of the major authorities who do a lot of this work tend to do more of the CM work on the large projects, maybe none of the hard bid work on the large projects anymore. Janet said she wasn't sure if claims are down. Speaking as an attorney, I've been doing construction law for 30 years. Claims are down. There's no question about it. There is a lower incidence of claims and litigation post-project on public projects that go out under a CM procurement than under the traditional Chapter 149 procurement. I'm absolutely convinced of that. I talked to a lot of my colleagues in other firms. We're pretty much unanimous in the outcome of that. Thank you.
Thank you so much. I think before we move to our final panelist, we need to thank everybody on this panel from Massachusetts who took the time to create some extraordinary presentations and provide us with so much valuable information in thinking through this issue in New York. So I want to say thank you. Now, Ryan, now it's all up to you. You're here representing New York State, so what do you think? How do we get to the Massachusetts Miracle in New York?
Well,
not that I'm putting you on the spot.
no, that's
like
one of the things I find interesting here is, as most of the people in this room know, we did, New York State finally put together a design bill 3 years ago. The impetus for that really was mainly we were just coming off of Irene and Lee as far as the flooding went, and then we also had the Tappan Zee Bridge. And so, as often is the case in New York, there was something that needed to be tangible for members of the legislature and for the governor to look at to say, okay, this is a real reason now to change or to try something new. And what I'm also hearing, which I find interesting, is that from the Massachusetts perspective, at least from the panelists here, cost savings don't seem to be the main driving force behind here. And in New York, I don't know if it's just the legislative process with the executive budget, which everyone here is familiar with, and the fact that our governor has extremely broad authority and much more authority in the executive budget process than pretty much, as far as I know, most any governors in the entire country. So our entire legislative session is focused on two spots. You have the executive budget that goes until April 1, when we now always get on-time budgets. And you then have what we call the legislative session, essentially, where you deal with everything else. I think from the legislative perspective and also from the governor's perspective, because that's where he's the most powerful, we've always seen this as a cost-saving issue. And so therefore it has been dealt with for the most part, and the talks that have gone on have occurred in the first part of the legislative process. And so that's something that I think folks here who are interested in trying to implement that have to think about, because if you're going to present this as a cost-saving issue, then you are talking about, you need to be talking to the governor right now, because now that the elections are over, he has about a month and a half to get his budget ready. And then you have, as a lot of people in this room know, a 2-month fun time where the legislature has time to respond, and we have to get a budget done by April 1st. If it is more efficiency, cost, just the transparency, those issues, that to me is more of a legislative a process. You have more time. You have more time to do that because you'll have till the end of June. So those are some things to think about. I think in New York, from at least my perspective, but maybe I'm wrong, we've always viewed this as a cost-saving issue. How do we get more projects out there? How do we have more tools, as Karen said in her speech? How do we have more tools to ensure that with the limited funds that we have and that we're going to continue to have, get more projects out? And so if that's not really what happened in Massachusetts, that's something I think the New York people need to think about, and that also plays into when you really start to think about, okay, when are we going to get the legislation? Because that's an important thing. There are really two sessions in New York. There's the budget process, and then there's the legislative process, and most people here know that, but that is something that is a little different here. So I know we're late. Those are kind of my 2 thoughts on it, but I'd be happy to take questions on it.
Why don't we start with a question from Terry?
That's right.
Well, and my only response to that is then consider. This is, we're here to listen, but consider pulling it out of the executive budget process, because the governor has appropriations that most people in here know, and when he submits his appropriations, the legislature has very limited ability to do anything to those appropriations. We can either strike them, agree to them, reduce them, or if we agree to them, we can then add on separately, in which he has line item veto. He then has the Article 7s. Again, a lot of people here know this. This isn't new to people. If it's not really an Article 7 issue, then pull it outside of the executive budget. Obviously, our governor is an extremely, whether institutionally he has the authority, plus just the personality of the New York governor, this governor and all previous ones, they are going to have a significant role in the legislature in the 2 months after the executive budget. But if it's not so much a specific amount, then maybe it's better to pull it out. It's just a thought process. I've always seen it as part of the executive budget process, and that just, practically speaking, makes it a lot tougher, because you're talking about a major piece of legislation that you've got to get all right in 2 months. It's when we get our really sleepless hours.
I think as a public owner, I don't want to mislead people to suggest that cost wasn't a driving factor. It wasn't the priority in getting the legislative reform, but as a public owner, to Janet's point, we weren't looking at, you don't have 2 projects, one that's design, bid, build, and one that's CM, that you can do a cost metric, and compare. But what you have in the CM, which may go to your budget argument, is that you have cost management and you have cost information right up front. And so as a public owner, because you have the CM in early and the design process in early, you get to make those decisions pre-project and sort of decide through the value management process what you can afford. And maybe as opposed to deciding it at a later point through a change order process, which has premiums or claims. And one other quick note is that from public owner, from both DCAM perspective and UMass Building Authority perspective, I would agree that claims are way down because we just have had this collaboration. So that's a cost component as well that we've seen.
Yeah, that's a very important point because it does reduce costs and there are opportunity costs in terms of other projects. But I want to see if there's any other questions. Yes.
The only hard data is probably through the Mass School Building Authority, which partially funds most public school projects in Massachusetts. And they maintain rigorous data on cost per square foot of different kinds of schools. And I think they would tell you that there's no meaningful difference in cost per square foot, final cost, between those that have been bid under Chapter 149, the filed subbid statute, and those that have been bid as a CM. I do think that the proponents of CM, really talking about public authorities, are looking to other factors and not that we saved money. It's more we were happier with the process, we were happier with the quality of people who were hired, we were happier with the outcome, not we spent less money doing this. So if you go to the Mass School Building Authority, MSBA, they do have some data on that that they might be willing to share.
Any other questions? Yes.
I would definitely say it shortens the schedule cycle, so you can get into the market sooner. Escalation is always going to go up, so that time value of money is real.
I would just simply say it comes down to what our collective experience, if you want to look at it from the 30,000-foot view, is. We started with a process with tons of projects, state-funded projects and municipal projects that were not coming in on time and on budget. And for the most part now, they are starting to come in much more on time and on budget. And the only difference, the only change that has occurred was we enacted CM at risk. So when we talk about costs, I mean, we all agree, yes, it may cost more just because you're paying for more things, but it's hard to quantitate, what is the cost to you for having a project done on time and on budget as opposed to $19 million over budget and 3 years behind schedule. So, it's...
Yeah,
again,
I mean, a
it's not something you can
sophisticated
quantify.
model would factor that in as a cost benefit. There's just no question about it. So it would be, hopefully at some point, somebody's going to do that kind of analysis because it's so compelling that maybe the quality is different. Somebody has to value that in the project, and that is clearly a difference in cost. If government decides to spend the same amount of money but gets something better at the end, then you've saved money. And I think that was partly what Terry was saying as well. And certainly the timing issue has to be factored in as a benefit too. Is there any other questions? One more. Go ahead.
That's a whole different issue. No. I will simply say from my point of view of having built buildings, utilities in Massachusetts are not beholden to anybody but themselves. So I've had many projects where we're at 50% design development and we're letting the utilities know that this project is coming and they say thank you very much, and when you get to 100% CDs, mail your check and then we'll start talking. So I don't know what the answer to that particular problem is, but in Massachusetts, my experience,
Yeah.
utilities are a completely, we could probably spend a whole afternoon talking about that.
I see an attitudinal difference. A contractor who has a hard bid under Chapter 149 is simply going to say, I bid the documents, and if you haven't come through with the utility, it's simply going to be extra money.
Yep.
A CM is more likely, because this is what they do in the private sector all the time, is to identify risks ahead of time and to talk about ways to mitigate or work around the risk. You are more likely to have a proactive plan to try to address it. With a CM, you are simply not going to have that kind of a plan with a hard bid general contractor who's just competing for lowest dollar.
And we have one last point.
Yeah, I just wanted to underscore that, I think it's been successful in Massachusetts, not simply because it's CM at risk, but because of the infrastructure that was put in place in that statute. It was a package, and a very big package. The pre-qualification, the certification, the project evaluations, the role of the inspector general, the continuing training is what is making it work, and not simply because we now have a CM at risk model. So it's all of those components, not just getting to CM at risk, that infrastructure, I think that is just critical.
Well, thank you all very much for an extraordinary panel. This has been really terrific. I think we're going to close it now and move on to the rest of the program. Thank you so much.